All righty. So
Bum, 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 bum.
I get a lot
Dude,
of
you
what?
look at Christopher's email for the 900th time.
Yeah. Proventa.
It's the first time, it's the
Providenta.
first time we all look at now because every time Christopher comes on,
Email me right now, and I'll
Goodness.
change it in the. I'll change it in
Christopher,
the
I
template.
apologize for our co-host here.
All right, so I get a lot of questions. We see a lot of posts on Facebook. Who do you recommend for as a real estate attorney? And there's some great real estate attorneys, but Christopher Charles is one of our real estate attorney for our team, and built a long-term relationship with him. Christopher, welcome back, and thanks for being on. When are you going to change your email address?
Actually, that's a good question.
I don't know if I should thank you.
Hold on, Nick. When are we going to
Sorry,
get Nick to learn how to
sorry.
use the
Listen.
equipment?
If I should thank you or take issue with that, but I read an article just last week in the Wall Street Journal that said how the pager and the fax machine are the new boss flex. So it's just something fun that we can kind of daydream about. The idea of getting rid of our email address and our cell phone to minimize the risk of everybody pinging us at all hours of the night all the time. But of course, realtors and attorneys, we don't get to do that. So I might as well include my legitimate email address because I do want to be a resource to you and your clients and help out how I can. That's why I'm here today.
All right. Well, Nick's going to message everybody and get the right email address. All right, Todd. I promised from the get-go we were going to talk about something today
I'm excited.
that we've never discussed.
It's a cliffhanger.
It is never discussed in the 10+ years I've been part of the podcast. So, Chris, we are seeing, and the reason we're talking about it because a lot of agents are going to be like, "Well, I haven't dealt with that. I'm not familiar with it." But with the way that the market is going and the way that we're seeing a lot more generational housing, this is going to become a huge, huge issue. And I do want to say from the get-go for our agents is we're going to discuss it, food for thought. But at the end of the day, this is one of those scenarios that we're definitely going to want to refer over to a real estate attorney. But anyways, Chris, this really just comes down to joint property interest, where let's just call them non-married people. But it could be generational housing. You got children and parents living together and buy a house together and so forth. So I'll let you take it away, kind of explain it and some of the issues that we're seeing.
Great. Thank you, Mike. Well, this is something that I am routinely seeing in my office, specifically over the last year or two, and it's trending to be more and more common, and I predict it will be more and more common for the rest of this generation. So I wanted to take a few minutes to just talk about joint property interests, which is one topic, and then a second but related topic, and that is the new Arizona law regarding guest casitas, and I'll explain how those intersect. Yep. If we have time, we can also talk about the so-called predatory listing statute that's brand new as well. But let's first talk about joint property interest. I'll start by telling a short story, a true story that I've seen happen again and again and again. And this was earlier this year. I guess we'll back up during the pandemic. During the pandemic, I have a client that owned a nice property on 1 acre, and it was a baby boomer family, baby boomer couple, and they'd had the home for many years. And it got to the point where it was a nice home, but it was just really more home than they needed, and more home than they cared for, and more home than they really wanted to maintain and take care of. So they started a conversation with the adult children about, hey, how about if we all move in together? We can have the grandkids nearby.
It's a terrible idea. That's a terrible idea.
We can share expenses.
Careful what you ask for.
And so they got into serious advanced conversations about that, and decided to build a casita on the property, so that way the older generation, the grandparents, could move into the casita. The younger generation, the kids, and then the grandkids could then move into the main house. So they decided to do that. They pooled their resources. They spent a couple hundred, actually it was a few hundred grand, building the casita. And everything was fine for a season. After spending all that money, going through all the work of building, getting the permits, building the casita, they moved in together, and it worked out for a season. But then we'll just say circumstances changed, and one of the families decided that they would rather move on, that they wanted to sell the property. That then presented the problem that I'm seeing happen again and again and again. And my law firm, our attorneys are going through a book each week on Wednesday mornings we're reading a book that's called The Servant Lawyer. And one of the chapters in the book talks about lawyers as builders or trustees. So not as destroyers or people trying to throw kerosene on the fire and fight, but lawyers as builders, as problem solvers. And so that's what I think realtors, lawyers can do to kind of provide really wise counsel to our clients, let them know, hey, these are great opportunities, great ideas, joint property interests, but they need to be handled very carefully, very thoughtfully, and preferably with an agreement. And I teach a class on real estate contracts, and one of the things I emphasize is one of the benefits of contracts is avoiding disputes. Sure, contracts can help solve disputes. There can be terms that help protect you if a dispute arises, but if a contract is properly drafted, thoughtfully drafted, and thorough, then hopefully there should be no dispute, because we want to have everybody's expectations spelled out in advance so that if a dispute happens down the line, or maybe memories fade, we can just refer back to the original terms of the agreement and resolve it that way. So that being said, there's 3 different ways that joint property interests can be memorialized. And actually, let me back up even further. The reason why I think this matters and why it's so common and will continue to be common is there's really 3 driving factors toward these joint property interests. One is the aging population. And there's various reasons for why that favors joint property interest, but the aging population, 2, we talked about that a little bit earlier, I think, with Matt and Nick and Mike about call them young adults, the Gen Z, some millennials that for various reasons prefer to be home still. And then also the delayed marriages, just family, we talked about that, families just getting married later in life. And all 3 of these issues lead to joint property interest, we'll say that. And in all 3 of those situations, there's a tendency, a propensity for the parties involved to say, oh, we have a close relationship, we're family, or we're lovers, whatever the case may be. We don't need to formalize this. We don't need to have an agreement. We'll work it out. That is the worst thing that you could do. So these agreements can help build, solidify, protect relationships. I'm just telling you, they're absolutely necessary, because I got into real estate selfishly about 20 years ago because I perceived that it was dispassionate, that it was not emotional, that it was not stressful in that regard. Well, let me tell you, a huge exception to that is these joint property interests. When you've got family members, mom suing son or daughter suing mom, it is absolute hell for the parties involved. So the parties owe it to themselves to think through and have this done correctly before they take that big drastic step. So one way that we can document that, there's 3 ways of owning joint property, having a joint property interest. One is through a joint tenancy, and that's most common usually with married couples. When married couples buy a property together, typically, presumptively, they'll take the deed as joint tenants with right of survivorship. In that instance, they both have an undivided, equal ownership interest in the property. So that if circumstances change, they both are going to get basically generally half of the proceeds from the sale. Also, if one of the spouses predeceases the other spouse, then the decedent's interest will automatically, by operation of law, convey to the surviving spouse. So that's joint property. It's usually reserved for married couples, but a lot of times what I see is it happens with unmarried people who are cohabitating, buying a property together, and then also in these familial situations where the grandparents and kids decide to buy a property together or build a casita together. So that's one way. But there's nothing memorializing what the parties' agreements are. So that says that we all own it together, but it doesn't say anything else. Another similar method of owning property together is a tenancy in common agreement, a TIC agreement. That is a undivided fractional interest. So it's not necessarily 50-50. It usually is, but it could be, different fractional interests in the property. For estate planning purposes, if one of the tenants in common passes away, their interest does not convey to the surviving tenant in common, but will, pass pursuant to their estate plan. And again, unless there's a separate agreement written, that TIC interest will have no other memorialization confirming what the parties' respective interests, rights, privileges, obligations are. And then the third is if the parties want to own it as an LLC with an operating agreement. Because typically, well, I shouldn't say typically, but with an LLC, hopefully there's a separate agreement, an operating agreement written to spell out what the parties' interests are. So that is really, really important when you have a client that is thinking about buying a property together with one or more other people. Really good advice you can give them is to think about drafting ahead of time, not after, ahead of time before closing, some agreement. Well, how do we want to hold title? And do we want to have some agreement that says, what's going to happen if one of us decides that we want to sell or the other one doesn't? That happens all the time.
Yeah.
That usually happens. Like, I haven't seen that situation yet where everybody just agrees in harmony, like, okay, great, yeah, let's all sell next week and let's hire Mike Weinstein and let's listen to this. It just there's usually competing interests, and if you have these things spelled out ahead of time, there's nothing to fight about. This is what we decided.
It's always best, Chris, if you enter anything, even an employment agreement or any contractual document. Everybody's all excited at the very beginning, and everybody thinks nothing will ever change their relationship. So a good document, correct me if I'm wrong, will always have the exit strategy identified.
100%, and that's a really important term and condition of a TIC agreement or an operating agreement regarding property is what happens upon one of the parties' death, incapacity, or desire to sell. And is there a right of first refusal? Do we agree to hold it for a certain period of time? Because that a lot of times there's unmet expectations. So like I see that happen where the parties say, after the fact, well, I thought that since we went through all this trouble and this money that we were going to agree to hold it for at least X number of years. And sometimes the circumstances change abruptly, 1 year later or whatever. And so one of them wants to sell quickly. So yeah, absolutely, that's really important.
One quick question on tenancy in common. Is it possible for one of the owners that are on that tenancy in common to sell their interest, and if the other party doesn't want it, they still have the right to sell it?
Generally speaking, yes, an assignment in real estate, including a TIC agreement, is assignable unless otherwise agreed. Mm-hmm. So if the parties negotiated a TIC agreement, which if we're talking about family,
right,
then that's important. Another scenario where this comes up all the time is cabins up north, where we've got siblings or just extended family that decide they want to pool their resources and buy a property in Flagstaff or Munns Park to enjoy together as a second home. But in those cases, like if it's not otherwise agreed in writing, yeah, like one of the aunt or uncle or somebody could sell their interest to some third party that the other tenants in common might not appreciate. So, but you can agree otherwise in an agreement.
Now, of the three, I would probably lean towards, and this is why, and I understand that we're especially from our brokers and corporate, we always tell agents, always, if you got a question, just advise your clients to talk to a real estate attorney. It's almost like a home inspection report, recommend further evaluation. But there's some situations where I don't even want to dabble in, and and this is one of those situations that I can't even pretend, because there are so many bad things that can happen. So of all of those three options, Chris, I would lean, if it were me entering into one of these situations, and or if I had a client saying, hey, I'm going to buy a house with someone or whatever the case is, I'd probably I'm going to recommend talking to you, but say my favorite would be an LLC. I think an LLC offers a lot more creativity and probably could be amended a lot easier because, like from, my partner and I, we, talk about our partnership agreements and so forth. But every week a new situation arises that we hadn't thought of when we created the document because because what happens when one party stops paying their portion of the utility bills? Or what happens if there's a flood and then one party doesn't have the cash? I mean, you've got to get pretty darn creative, especially if they're non-family members.
And that's,
Especially if they are.
especially if they are. But that's one of the benefits of encouraging our clients to sit down and think about this, because a good real estate lawyer can present them with ideas they hadn't even thought about. These options that everybody just goes into it with rose-colored glasses thinking it's going to be smooth, it's going to be fine. But if you start letting them know, well, what if this happens? What if this happens? Let's decide ahead of time, because whether we know it or not, we all probably are entering into the agreement with certain expectations, many of which are not communicated. Let's get them all on the page. Let's agree ahead of time. But by the way, operating it's tricky. It's tricky, and I think it's a case-by-case scenario, because if we're talking about a primary residence where the parties are going to buy this property together, buying it in an LLC pursuant to the IRS is going to waive the $500,000 primary residence exemption.
It sure does.
So that's a pretty
Yeah, but you wouldn't buy it as an LLC. You would put into an LLC post.
The IRS is still going to
Yeah.
take issue with that when you ultimately sell the property. So at least that's my advice to clients. If we're talking about their primary residence, I have some clients that don't care.
Yeah.
That the property is expensive enough, they don't care. But most people are going to say, yeah, $500,000, that's enough money where I'll go ahead and put it in my family trust or in my name personally. And then you can still use a TIC agreement to really spell out everything that you would put in the operating agreement.
Yep.
It's just called something different.
All right, so going back to the story, kind of like a cliffhanger there. Like one party wanted to sell, one party didn't. What happened?
Well, if we don't have an agreement that was negotiated and executed ahead of time, then the only option is to file a partition action. If the parties can't agree, then we do have a statute in Arizona that authorizes the court to compel the property to be sold. And some of you have probably been involved in those transactions where the judge can appoint you as a licensed real estate salesperson or broker as the special commissioner to list and sell the property. And then the proceeds get interpled with the superior court, and then the judge will ultimately conduct a hearing to determine the parties' respective equitable interests in the property. At the beginning of the case.
All right, so we have joint tenants and community property.
Yeah, my view is that joint tenancy with right of survivorship, that makes total sense for married couples. It makes less sense in most other situations because, hopefully the couples are getting married for life, and that's usually going to be most people's estate plan, that if one spouse predeceases the other, they want their interest to go to the surviving spouse. So that makes sense for a lot of people in a marital context. Outside of a marital context, it makes less sense, frankly. Yeah. And I think the other options of holding title probably are more relevant.
Second marriages, or the second marriage that comes in their blue-haired years, where they just want to be with someone, they don't want to be alone. So two parties that both have inheritances to their children get together, want to buy their final home, and sometimes again you have to talk to a real estate attorney because we can't tell you that. But sometimes TICs work in that environment because now that portion of the house can be heired to, to the one party's estate and the other to the other. So I mean, it requires so many questions. Here we are this morning on the 3-pack talking about, the 3 questions that need to be asked. This is that very, very first question. When you start getting this information, I have a great real estate attorney. His name's Christopher Charles.
Yeah.
I recommend you talk to him before we enter into any of these agreements.
Yeah, but if you are going to reach out to Christopher Charles, based on my recommendation, make sure you get his email right because that's going to bounce back if you just do it as on the slide. All right, I want to get into this predatory listing stuff and employment agreements. In recent years, we saw a company, and I don't remember the name of the company, pretty much. And if I botch some of the details, forgive me, but you should be used to it. I do it every week. Lend a seller a home, or lend a homeowner some money. In exchange, that homeowner signs a listing agreement for 5, 10, 15 years.
40 years.
40 years. Yeah. Records the listing agreement, and with the idea that company, that's where they were going to get their profit. And so now they lend me as a homeowner some money. I send a 40-year listing. If I ever go to sell that house in the next 40 years, this company now is the listing agent. And I can't get around it. And people couldn't get around it, but recently the state of Arizona stepped in.
Commerce statute.
That's right.
Did I botch the detail?
No, I think that was a
Nice.
pretty good summary. SB 1218 was passed and enacted by the legislature at ARS 44-501, which summarizes, which states what Mike just summarized, and that is it's the so-called predatory listing law that prohibits these listing agreements from exceeding 12 months in length, and prohibits the listing agreements from being recorded with the county recorder's office. Those are the two primary takeaways from the agreement, aimed to curb that type of practice that was happening, just a few years ago. Regrettably, it has some unintended consequences that are not particularly helpful for some real estate professionals. One of the issues that's come up is questions that's come up is whether that applies to new home construction. Because as we know, new homes are not built by Amazon and they don't happen overnight.
Yet.
Although I think, you could probably get a tiny home from Amazon, but many times the process takes longer than 12 months. So I recently reached out to the real estate commissioner to get an opinion, to get an advisory opinion on, with her agreeing with me that does not apply to new home construction arrangements, but her opinion is that it does apply to new home construction as well. So people involved in new home sales have to...
Yeah, Todd, because that was the problem that I brought up to Christopher, is I represent a buyer. We've signed a buyer-broker agreement, and now with the statute, the buyer-broker agreement cannot be for more than 12 months. But let's say now it's a 15-month build time. Yep. And I know I'm putting you on the spot.
No, I'm real familiar with the change. And so I can tell you this, that in the agreement, it does not prevent the agreement from having an extension provision. So it's just the main agreement cannot exceed 365 days. But here's the kicker: 365 days from the date the person signed it, not from the date the agreement commences. So in most employment agreements, you need to have or contracts typically, in this particular case, you'd have a beginning date and an ending date. That can't be longer than 365 days unless, or not, period. But you could have a provision set in there that allows the parties to come to an agreement to extend it. And so that's somewhat solving in many instances, or at least attempting to solve. The other piece is, and I'm not a real estate attorney, so this is just what I've been told. But the other piece of that is also, if you do create one and it's longer than 365 days, I believe it's 44503 says that it is void.
Right.
It's not a contract. That person can just go away and do whatever. They're not held accountable because you exceeded what the statute required.
Yep, that's right. And I'll put it this way: realtors that are entering into these agreements, anticipating that the performance term is going to exceed 12 months, are they're taking on risk. Well, let's put it that way. We can ask the client to agree to negotiate in good faith for extensions, but there's nothing stopping. When we get to that 11th month mark, 12-month mark, there's nothing prohibiting the owner of the property from saying, no, thank you. I've decided to go a different direction.
It's an option to enter into it, not a demand.
Correct.
Both parties have to mutually
we got
agree.
about 2 minutes here, Chris. What are some? We didn't rehearse this one, but what are some common things that agents are taking upon themselves, instead of really saying and really advising their clients, you need to talk to a real estate attorney. Because I know we say that all the time. Sometimes, we just say it to, CYA, but sometimes we're taking too much upon ourselves in understanding or explaining, the contract or some situations.
Well, specifically in regard to the contract, I would just encourage agents to look at real estate lawyers and the broker as a resource in helping to document, unusual terms and conditions in the agreement. I mean, the type of cases that come to my desk, have addenda to the purchase contract that are like single space, multiple pages, with all kinds of unusual terms and conditions outside of the boilerplate language of the contract. When we start getting into, additional terms and conditions, different agreements, contingencies, that type of stuff, just, reach out and have us help through that process, or just look over your back. That way you're not taking on that role.
Quick question about that. So I'm explaining to Mike the terms and conditions of the contract before he signs it. I'm walking him through the contract. And I tell him about what each provision means, basically. And he has a question to dig deeper into that particular provision. Is that something a real estate agent should get involved in, or is that a time when it might be a red flag to submit that to the broker first and then the real estate attorney? I mean, how far does our right under Article 26 go that allows us, because it doesn't allow us really to practice law. It allows us to draft an instrument incidental to the transfer.
Well, I think incumbent in that right to draft is the presumption that you're going to understand it well enough to be able to explain it.
Okay.
So
Big assumption, pal. I want to
So
introduce you to some
I
people.
just
else.
think
Also
the
be
agent-
responsible for what you say.
the agent just has to use discretion in evaluating that. But I think, explaining the general terms of the standard form agreement are fine. But you use your intuition, your gut, and if you think the client is a red flag, or maybe going to be some trouble, or if it's something that you really don't understand, you're not super comfortable with, bring it to your broker.
Perfect.
All righty, this is Christopher Charles with Provident Law, and Christopher Charles his firm is the firm that I send all of our clients to when they have real estate questions or need, special addendums, or now with this joint property interest, definitely you need a place to send your clients to. Be careful, and also we didn't mention, and I'll just say, if you have a client needing any kind of advice in navigating HOA disputes, Christopher is one of the leading experts when it comes down to dealing with HOAs. Chris, thanks so much. Appreciate the time. And you owe me breakfast because you bailed on breakfast this morning. Ooh. All right, leave everybody with the quote of the day. What you get by achieving your goals is not as important as what you become by achieving your goals. I read this. I read this morning. Nick, I was prepared. All right, everybody. Appreciate you joining us. Go out and sell a home.